Honorable John Wao for success achievement of Alessandra, the daughter, and actually it was aired on SBC last night. But this is something very good. It's a very good example for members of the National Assembly actually pushing the kids, the children to achieve the highest result possible. Congratulations, Honorable. And this is something positive, and any member of the National Assembly has such, their kids, their children achieve such results and all that, please do let me know. And I will share that also with the public because we are here to set examples. All right? Bonjour tout le monde téléspectateurs. Juste pour faire autre matinée pour dire aujourd'hui, deuxième jour qui nous peut faire notre travail pour nous capables continuer cette discussion le code civil. Et ça nous peut faire, par exemple, nous annoncer hier, d'une façon préliminaire, avant l'Assemblée, ils débattent le son bill, et avant l'Assemblée, ils prennent une décision. Okay, so we will continue where we left yesterday, and today we're supposed to start with Articles 258 onwards. It's property orders. Okay. Yes, Honorable Basil Wao.
Mr. Chair, thank you. I put on 248 and have we covered that? 246 onwards. I don't believe 248. No, yeah.
Separation?
Yeah, 246. We have to. Yes.
Okay.
5, 7.
Matrimonial causes.
Yes.
Okay.
And I also want to point out something which I noticed after yesterday's session regarding there is a slight mistake. And it's a slight mistake, but the effect is very substantial. It's in Article 2381. No, 2382. 2382A. Sorry. Yeah, which provides that the court shall not grant an order of nullity in the case referred to in paragraph 1A. In the case referred to in paragraph 1A. And then it says unless. And presently it reads unless the wife had become pregnant since her marriage. There is a mistake here, and in fact when I compared it to section 12 of the Matrimonial Causes Act, from which it has been taken from, the unless should be after Roman 1. It should be in the case referred to in paragraph 1A, Roman 1, unless proceedings for the order or nullity were instituted by a party. And 2, it should be if the wife had become pregnant. Because 1A is a party to a marriage had not at the time of a marriage obtained the consent required under this code. So it should be if. Then you cannot, if the wife is now pregnant, you cannot ask for nullity. But the way it reads now, it's as if the wife is not pregnant, you cannot ask. And actually, when one looks at the provision of like I've said, section 12(2)(a), it says, in the case referred to in subsection 1A, Roman 1, unless proceedings, and then Roman 2, if the wife had become pregnant since her marriage. I think we need to correct that. It's a small amendment, but the impact. Thank you. Thank you.
Okay. All right, so we'll okay, so yes, Honorable.
Sorry. I see what Honorable
Wawo is saying, to insert the if. But do we really need to insert the if? Because from my understanding, the two is there just in case the wife is pregnant from through the man, through the husband, and therefore the marriage cannot be declared null and void. Well, the proclamation of nullity cannot be declared because then this would mean that the child would, when the child is born, he or she would be born out of wedlock. So do we really need an if?
Yes.
Or is it sous-entendu and it is clear? Because, or the wife had become pregnant since the marriage. I think the since the marriage is the imperative words. It's to do with since the marriage, meaning that the pregnancy occurred within the marriage.
Okay. Yes, Honorable George.
Yes, in fact, they're both right, and they're both right. The reason for little 2 is the one given by the leader of the opposition. You obviously don't want to annul a marriage where there is a pregnancy, but I think the word unless, when it refers to little 2, says that the exact opposite of what it intends to say. So yeah, I think if would be a better word than unless. So we'll tidy that up.
Okay. Good. Okay, shall we take Article 246 onwards? Matrimonial. Yes, Honorable Espao.
Thank you, Mr. Speaker. Good morning, everybody. Mr. Speaker, before we move on to 246, I've got a query in 244, separation. I think we did not touch it yesterday. I would like to know, I know in the practicality before, the judge would give a couple separation. Is there a time frame before giving the divorce? I know sometimes the couple will have a separation just to take them apart while they were living together, so just to calm the situation before giving a divorce. Is there a time frame before the judge can give the divorce after the separation? Thank you.
Okay, thank you, Honorable. Honorable George.
Thank you, Mr. Chair. The separation here is what used to be called judicial separation. It's basically designed for people who want to live apart, who are married, but who don't want a divorce, usually for religious and moral grounds. This is what this is. Because you have to prove exactly the same as you would for a divorce, but you don't ask for a divorce, you just ask for an order of separation. It's very rarely used, and as I say, it's used pretty much for people who want to separate, but for religious and other reasons don't want a divorce. What I think the Honourable is talking about is something that I don't think exists anymore. It used to be called a non-cohabitation order, which the Magistrates' Court made under the Summary Jurisdiction Wives and Children Act, and which perhaps now is made through the Family Tribunal. We called it, in Seychelles, in Creole, a séparation. That's why we confuse it sometimes with separation. But the actual word was non-cohabitation order. And all that did was to tell you, you don't have to live with your husband or you don't have to live with your wife. You're still married, but you're allowed to stay away. Basically, you're allowed not to give conjugal rights to the other party. Okay? You're allowed to refrain from giving conjugal rights. It's very rarely done now because people just leave anyway. You don't have to go to the court to get an order that you can leave your spouse. You just walk out, and that's what happens. So that has fallen into desuetude over the last few years. But to answer your specific question, no. If you get a non-cohabitation order, you can get the divorce the next day. If you get a separation, you can get a divorce the next day. There isn't a time limit that you must go through.
Okay. Thank you, Honorable George. Any other queries with regards to separation, the section on separation? If not, we move to Article 246, matrimonial causes. Yes, Honorable Ade.
Thank you, Mr. Chair. Mr. Chair, with regards to 461, I would read it and propose what I am trying to propose. Subject to paragraph 3, a party to a marriage who alleges that reasonable ground exists for supposing that the other party to the marriage is dead may petition the court to have it presumed that the other party is dead and to have the marriage dissolved, and the court may, if it is satisfied that reasonable grounds exist. My question is, why didn't we put shall? Because we have left it may, and even if reasonable grounds, because we say may, if it is satisfied that reasonable grounds, and even if it is satisfied, there's the may. So they may not. So my query is, why don't we make it when there is the grounds satisfaction? So why don't we compare them to issue an order, because the satisfaction is 7 years, the satisfaction is 7 years, and after other reasons has come in. So my concern is with regards to this. Thank you.
Okay, thank you, Honorable. Okay.
Yes.
Yes. Any other queries? Yeah, 2461.
So I don't have the comparable provision of the Matrimonial Causes Act open at present, but I'm pretty sure that is the current law, and we've noted that the comment, and that's a proposal that the Bills Committee and the Assembly should take into account in due course. Good point.
Any honorable?
I'm just thinking aloud. The fact that the sentence begins that the party to a marriage alleges that reasonable grounds exist for supposing. So it's all, there's nothing definite. It's all on a presumption that the other party is
presumed.
there. So maybe this is why you have the may and not the shall, because then the may can become a shall if if the evidence is clear that yes, the party is dead, and therefore the court shall. But if the court is still not sure that the party is dead, the court may say, I'm not convinced that the guy or the husband or the wife is dead. Therefore, I will not grant. I think it's. We go back to the door, living a door, for. You have to leave this door open.
Well, the honourable member's point, as I understood it, was that once the court is satisfied, that should automatically convert to a shall, rather than the existing may.
Yeah.
But I think the whole paragraph casts a shadow. I mean, you start with alleges, reasonable grounds, supposing. Then you go on and you use presume.
You have to keep a The may is the door.
Yes, Honorable.
The may is a door, as you said, but the may here is conditional if it is satisfied, reasonable ground exists. So once it is satisfied, there should be no may. There should be no may. The may cannot be converted because a may, a convertible may, will always remain a may and shall never be shall. So let us make it clear, because the aim of this exercise is to put clarity where doubt exists at the moment. So let us not leave a doubt when we are meant to be clarifying things.
Unless, I mean, if I see your point, I think if you use shall, the whole paragraph has to change. But in this instance, may suits the wording of the paragraph. Honorable Basil Wow.
I can see the point being made by Honorable Andre, but at the same time, it is well established as a rule of interpretation that may can be construed as meaning shall.
Depending on context.
Exactly, and I believe in this context, may can be construed as meaning shall, and I don't believe we need to
Change.
Yes. I think it reads better in this context, but in that context, may reads better in the context, but in this particular context, may can easily be interpreted to mean shall.
If you substitute shall will close the door.
Yes, it is meant to close the door. It is meant to close the door because we want clarity. We want clarity in this exercise. Not so that we come back in 2 years' time and say, you know, we made a mistake, we want to clarify now. Let us clarify, because this is exactly what Honorable Afif queries were yesterday in terms of, you know, have we gone through this? Have we done it? We are doing it now. Let us do it properly. Shall, because we have seen may, which meant shall, never became shall, depending on circumstances. So let us make it shall, so that it is clear to all of us.
Yes.
Thank you. Yeah, thank you. I have a few questions. Why is this provision proposed when you have a presumption of death act and it should be dealt there? How does it articulate with it, I mean? Because do you have something about regime absence, where you presume the person is alive, disparition, where you presume he's dead, he's gone to the sea, we don't see him? It must be read together with that, I guess. Or does it derogate from it? Yeah.
I think this is obviously, all these points are very good points, and I think the drafter, the original drafter of this section was not us. First of all, I think this is here because it deals with not only the presumption of death, but the dissolution of
Yes.
the marriage following the presumption of death. So that's why it's in this area.
Because that would happen.
Well, it doesn't automatically happen. No, you see, this is the thing. The court, and I think that's why the use of the word may was used, because the court, even if satisfied that a ground has been established for the irretrievable breakdown of marriage, the court may still refuse to grant a dissolution, despite having been satisfied of the existence of a ground. And I think this goes along with this, that the court has a residual discretion, even when it finds that there is sufficient ground to establish that the person has disappeared or has died, not to grant a dissolution of the marriage. I think the may comes not with regard to the presumption of death, but with regard to the dissolution of marriage. I think that's...
You have in your system, the judge may declare the person dead.
Yes.
Of course, if he comes back, that's another matter. Which has happened. But normally he should dissolve the marriage because that's not the natural consequences of the death, and even distribute his property.
Well, not ipso facto. You see, this is the point. It doesn't
Because of
automatically
that,
follow.
yeah.
It doesn't automatically follow. You see, if you go under the Presumption of Death Act and you ignore Article 246, you go under the Presumption of Death Act and you say, my husband has disappeared and we can't find him. I want a declaration that he died. The court has a discretion to say yes. I think the facts point to death,
Yes.
so therefore we'll presume his death. Or no, we don't think that the facts amount to that, and we will presume him absent. We can open the succession even on absence. We don't have to wait for the presumption of the declaration of death. And I think this is the same. Foot on the brake here. It's to say the court may. So, in that sense, you could construe it as shall in certain circumstances, but there is a residual discretion left in the court because the court is presuming a death and therefore establishing a dissolution from a set of presumptions rather than from the establishment of certain facts before it. I think that's probably why there is this ambivalence in the article.
But Honorable George, can the situation I actually outlined yesterday, can this article be used in the absence of the partner who's actually left the country for over 20 years now, over 15 years? Can that article be used by the other partner and say that I presume that he's dead?
Well,
yes,
well,
but he's disappeared. And
it can be used, but the court will be very reluctant to be satisfied that just because a person hasn't communicated with you for 15 years and that you don't know where they are, that they are dead. The court might say, well, they just don't want to communicate with you because they're fed up of getting your letters or whatever. So you cannot make the leap to death. So I think...
So you can't use this?
No, because there are other easier avenues for you.
Yes. Okay, thank you.
The very famous case of Félix Morel on Farquhar, who disappeared into thin air, almost in full view of everybody else, and the court 3 times it's been to court, to the magistrate's court, to the Supreme Court once, and to the Supreme Court the second time, and they cannot say for sure that he died. So, because there are elements still not available.
Okay, thank you, Honorable George. Any other queries on matrimonial?
I think, Mr. Chair, just for people's, just for everybody to understand this, this section
Changes to this section?
No.
deals with relief following divorce. Yes? And if we go to 250, you will see the kind of relief. This is in the current Matrimonial Causes Act. The kind of relief that the court can give to a party. Money, a lump sum, maintenance for the child, and all that sort of stuff.
This hasn't changed much, no?
This has not changed, I don't think, at all. I'm looking for, Professor perhaps can help me, or one of the other lawyers, the provision for property adjustment.
That's 259.
We've removed it from here. No.
No, you've
No,
got
here you
the,
go, 256. You see, 256, without prejudice to any other power of the court may, on the application of party of marriage, grant such order as it thinks fit. C, in relation to the property of a party to the marriage or the matrimonial home. This little phrase here is what allows the court, after a marriage, to say, despite the fact that the property is registered in the name of the husband or the wife alone, the other party can have a share in it, a proprietary right, a right to property. So this is what allows the court to adjust. And we will see later on a bigger provision. But this little thing here is borrowed from English law, almost verbatim. This allows the court, after a divorce only, we're still dealing here with divorces of married people only, not cohabitees. This allows the court to make an adjustment of property and to in fact take it away from one and to put it in the name of the other, or to give the one who is not the owner legally occupation of the house, despite the fact that the one who's the owner might not want it, or to make generally an adjustment that you say usually the wife has a quarter share, or a half share, or a 1/3 share, or a 1/10 share, depending on several circumstances which we'll come to. I just thought I would highlight this now so that the context of what we will look at later will be clear.
Chairperson, sorry.
Yes, okay.
We have a sort of similar provision in Mauritius, but it concerns l'usage exclusif, not the ownership, but l'usage exclusif. Because unless your constitution permits it, can you just, through operation of the law, decide that this person is no longer the owner and the other one is? I think I have a little problem with that.
Well,
yeah. Or you may have constitutional cases arising. I mean,
there is a derogation to the right of property which allows the court to make this adjustment. So therefore, this becomes constitutional.
Yeah, okay.
But it's not only in Seychelles. It's not usage. In Seychelles, the court
ownership
can give
itself.
ownership, property rights against the wishes of the property owner to the other spouse.
And that's a permissible derogation to right to enjoyment of property.
Enforcement of an order.
No, no.
Court.
Okay.
It's a permitted derogation.
But okay, when you're talking about, Mr. Domingue, about l'usage, does that mean that in the process, the court can actually give one party the right of l'usage to remain in the house pending further?
Yeah, the ownership would still stay with the husband if it was his bien personnel, but just in the interest of the children and of the wife who do not have the means, they will use the matrimonial home exclusively, because his presence also may not make the living peaceful, but the ownership remains. Yeah, just reserved, but not.
Thank you. Honorable Basiwao. Yeah. Honorable De Comamo.
Just a clarification. That means if the property was acquired or was bought during marriage and it was put on one person only, or you mean property that was acquired before marriage and after the divorce, the same thing will apply, or?
You will see from 2561C that it is a very vague and very wide provision. The court can make such order as it thinks fit in relation to the property of a party. So it's a very, very wide discretion given to the court. And the courts have, in Seychelles so far, treated this as relating only to matrimonial property, quote-unquote matrimonial property, i.e. property acquired during the marriage or in respect of the marriage. It might have been, people have been living together before and then get married, so it's treated as having been acquired during the marriage. That's how far we've gone. And the courts have used 3 criteria. Let us use an example to make it clear. Husband and wife get married, they have nothing. They then buy a property and they put it in the name of the husband alone. They are married, they've got to be married here. They put it in the name of the husband alone. The husband pays all the housing loans all the time because he's working. The wife is a housewife, she stays at home, she minds the children, she cleans the house, she does the washing, she does the cooking. Okay? After a period of time, the marriage breaks down. Everything is in the name of the husband. Does the wife get anything? This provision allows the court to give her a share in the house and to say, by virtue of the fact that you've been a faithful housewife, you will have 10% or 25% or 33% or half.
You've done all the
Half.
housework.
So that is what the courts have done. But it's very rare that this is the case. Usually, the wife goes out to work as well. And usually, she sometimes pays part of the loan, or for some period of time when the husband can't work, she pays the loan. So all of those things are looked at. And the court usually uses 3 criteria. Has the person who is not the paper owner, okay, the registered owner, i.e. the wife in this case, has she made a direct contribution in money, either cash or by paying the loan? Secondly, has she made an indirect contribution, i.e. she has helped to carry the blocks while they were building, she has helped to paint the walls, etc. And thirdly, has the marriage lasted long enough, even if she has made no contribution at all? For any one of those 3, or a combination, which is usually the case, the wife can get a share in our context. That's what's been done. But it also works the other way. If the wife is the owner and the husband, there is no discrimination here. It works both ways. That is how far we have gone in this country. Now, to answer the question of Honorable De Covamo, in England, courts have gone further and have said even property that was acquired from inheritance, or in the cases of huge wealth. Paul McCartney and Haley Mills is the case in point, okay? We won't talk about Miller, but let's talk about Paul McCartney and Haley Mills. He made all the money. He was a Beatle. He has £500 million. They get married for 4 years. She gets a share. Even though she has done nothing to contribute to the patrimoine, she gets a share because he is so wealthy that the court cannot not give her something. So they give her a share. And that share, in the cases of real big wealth, can go to 50%. So even if you've done nothing as a wife, you can get a share on the basis that you cannot leave a marriage empty-handed just because your husband is extremely wealthy and has made the money elsewhere. So, but the courts have not gone this far here yet. Okay? So this is just to explain to you the situation that the courts have when. But I think the point to retain is that the court can give a person who is not a legally registered owner in a marriage relationship a share in the property owned by the other one, until they become co-owners.
But of course, the reason why she got the money was because she didn't believe in the song "Let It Be."
Thank you. Honorable William.
Thank you, Mr. Chair. Mr. Chair, I want to take you to Article 250(1)(a). If the members of the panel or Honorable George could give some clarity regards to payment for such period not exceeding the joint lives of the parties. I mean, I just want some clarity on that, because...
Yeah, basically this says that upon a divorce, the court can make one of the parties pay the other one a maintenance, an alimony, periodical payments, that's what it is. But this will not last beyond the lifetime of the person that you are paying. It will stop with death. The joint lives. Okay? The joint lives stop when one dies. Then it's not a joint life anymore, you see? So it will stop. If I die before and I'm paying, the payments will stop when I die. Or if she dies and I'm paying her before me, the payments will stop when she dies. That's basically what it says.
Okay. Thank you, Honorable George. Honorable Basil Wao.
Thank you, Thank you, Mr. Chair. Mr. Chair, there's one point I want clarification from the professor or from Mr. George, from Honorable George, since he was a member of the committee. 256. 256 is basically taken from Section 25 of our Matrimonial Causes Act. And that is when the marriage is still subsisting. It is not at the time of divorce. Because it reads clearly, without prejudice to any other power of the court may, on an application by a party to a marriage, So the marriage is still subsisting, and the wife can say, look, I want half share in property X without going for divorce. So that is clear. Now, if we go to Article 250, which is the equivalent to Section 20 now of our Matrimonial Causes Act, and there is a change. I've said equivalent, yes, to a large extent it is equivalent, except for the following change. And that change is in respect of now Section 21G. 21G. 21G presently reads, to the effect that the court can make financial adjustment, reads, make such order as the court thinks fit in respect of any property of a party to a marriage or any interest or right of a party in any property for the benefit of the other party or a relevant child. That's gone. And the only plausible explanation that I can think of right now is that, is it because we now have 259? Is it because we have 259? But 259, there is something we have to bear in mind. 20G talks also of a relevant child. And 259 does not refer to a relevant child. It is only in respect of the party. So basically the court will not be able to, presently the court, in respect of an application for divorce, and when there is an application for ancillary relief, it can make an order granting a child, a relevant child, interest in a property. But now that will be gone, and that child will not be covered by 259. True, a spouse will be covered by 259. So we have to bear that in mind. There are other issues, but I will address them.
Yes, yes. Thank you, Honorable Wawo. Honorable Ade.
I believe Honorable George had gone to 250. I was, whilst I was still looking at 247. But anyway, we've looked at 250, now 256 by Honorable Wawo. With regards to 247, my issue is to Professor, the way 247 is worded, to me, it is a safeguard with regards to 246 because it is compelling the Attorney General to look at every matter. Every matter, it says, that the court thinks appropriate, and such shall be done by the Attorney General, and the court will also ask counsels to address issues that it thinks is appropriate under these circumstances. So again, I don't want to dwell on this issue, but I feel that the safeguards placed in the law as it is now, so to allow us to really address the issue that is in 246. That's my concern. Thank you.
So you're satisfied now? We leave the May where it is.
He's supporting shall.
Honorable Wawo.
Yes, thank you, Mr. Chair. Mr. Chair, regarding what is now Article 248, 248, which is a replica of Section 18 of the Matrimonial Causes Act. We've used the term welfare. Subject to Article 225, the court may make such orders as the court thinks fit for the welfare of a relevant child. Welfare, I know, is wide, care, custody, and so forth, whereas Section 18 now specifically uses care, custody, access, and so forth. But when we read it in line with 2552, Article 2552, refers to access, care, custody, maintenance, education, otherwise. Okay, but my point is, okay, we can keep welfare. I have no issues. Relevant child. Relevant child. Relevant child is not defined presently. I don't see in the code where it's been defined. In the Act, it's defined. So we should not lose that definition. We should incorporate that definition of a relevant child in the code. Because we've used that term, but there is no definition. Whereas in the Matrimonial Causes Act, where it's been used, it's been defined. Well, it's basically the its definition is a child of both parties to a marriage, a child not being a child in the care of a director responsible for children affairs under the Children Act, and in respect of whom a party to the marriage is acting as a foster parent under the Children Act, who has been treated as a child of the family by the parties. So I think we should include that definition for clarity. And is there any other issue? Then Article 249. 249 is maintenance spending suit. Maintenance spending suit. And in fact, if I may digress a little bit, I was just thinking last night whether we should not have marginal notes. I know I'm going to increase the workload for the professor, because in Matrimonial Causes Act, we have marginal notes. And it's easy to refer to that relevant provision. But I know in the code, the civil code itself, presently, we do not have marginal notes. But I was wondering, since we're now incorporating the provision of Matrimonial Causes Act in the code, and there are also the provisions which are being transported to the code, maybe marginal notes. It will be helpful, I believe, if we can have marginal notes. But what I'm saying regarding now with maintenance spending suit is that when I read 249, the way it's worded, it does not automatically convey the message that this is a provision regarding maintenance spending suit. The only way I can, if this is clear, is when I read it subject to 252, which says proceedings for maintenance spending suit under Article 249. So now it is clear that 249 is maintenance spending suit. But it's when I read it together with 252. But I was just wondering whether we could incorporate into 249 itself that on a petition for divorce or nullity of a marriage or on an order of separation, the court may make such orders for maintenance spending suit as the court thinks. As the court thinks reasonable. This, as the court thinks, it's already there. I was just wondering whether we should insert that. Thank you.
Where to find?
249.
249.
To clarify that it is pending suit.
Yes. It is clear, but when you read 252, it's clear. But if we could just insert that in. Thank you.
Okay. Honorable Afif.
Thank you, Mr. Chair. Mr. Chair, my point follows very much along the query that Honorable Wao was putting. When I look at the original Matrimonial Causes Act, which we're now repealing, and in transcribing all the clauses, I find, for example, in the Matrimonial Causes Act, which is repealed, it had subsidiary legislation, Section 27, Matrimonial Causes Rules, which were introduced in March '93. The whole section on rules, and there were forms, up to 11 forms on there, which I don't find in here. It had all the ways by which these petitions would be presented, motions should be presented. All of these have gone. They're repealed. But I don't see how they come in here. Is there any specific reason? What has disappeared? What have we lost out now? Because this was quite recent, '93. But it's gone. And I don't see any of these sections appearing. Isn't that reason to suggest that why didn't we leave the matrimonial causes the way it was, or decide to amend it, but look at section by section and decide what was, no longer relevant and change? And then once this was done completely, then perhaps at some later point, ask for it to be repealed and transcribed into the civil code. Why are we doing this and we're not sure what has changed? And here it's substantial.
Thank you, Honorable. Yes.
Can you address this,
Professor?
To a degree, this matter was touched upon also yesterday. The honourable member raised a question about subsidiary legislation and the rule-making power in Article 2281. The direct answer to the question about the rules is in the consequences bill, where in clause 4, paragraph 2, subsidiary legislation made under the Matrimonial Causes Act in force at the commencement of this act will continue in force. So those provisions are saved, and I think it's section 16 of the Courts Act which empowers the Chief Justice to amend rules relating to the procedure of the court. So the intention was not to change that, and to preserve, pending any future legislation, to preserve the current matrimonial causes rules.
Sorry, where is that stated? Under
It's,
the
in
Civil
the,
Code of Seychelles consequence of enactment?
The bill number 14, I think the back page, clause 4, transitional and savings provisions, paragraph 2. Yes.
Yes, Honourable George.
Could I just address a very important point that Honourable Wao raised, which I don't think we should lose, and that is the question of the ability or the powers of the court to make property adjustment orders, not only during the marriage, but after divorce or upon divorce, in respect of the child. And I think he's right up to a point that we, in taking out G from 250, we might have lost something. Now, in 259.5, a child is included, but it's only in respect of an order made during the first 7 years, and not after. And it may well be, and I would prefer, to leave a greater discretion with the court, both before and after, to make property adjustment orders as it thinks fit, including in respect of the child. Because in 259.1, the presumption of equality only applies to the parties and not to an order in respect of the child. Whereas the court has a discretion before 7 years to include the child in 259.5. And I think it would be wise to have the same power right throughout, okay, so that the court has a full discretion. So I think we need to revisit the point made.
Thank you, Honourable George. Honourable Wao.
It's just a minor point. It is in respect of 2543. Reference is made to Article 259. I believe that is a mistake. That should be 250. No, yeah, it's we're referring to Article 2543, and it reads, the court shall not exercise its powers under paragraph 1, i.e. to vary or discharge or suspend in relation to an order under Article 259. Cannot be Article 259. I believe it's Article 250. 250.
Nine, 254.
Okay, thank you, Honourable
Three.
Wao. Yes.
Yep.
Honourable George.
I have one other thing, and I think we need to be very careful. In fact, this exercise is amazingly useful, if I may say so. You see, under 259, and I see the reason, because of the presumption that where a relationship has subsisted for 7 years, there will be equality in distribution. We have to exempt property which is inherited or has been acquired by gift or whatever, because you can't expect just after 7 years that the other party will get an equal share of property that you have inherited or that you have obtained by gift. That is very understandable. It's only with respect to the property that you have acquired together that there will be an equal sharing, because the time is so short. But what happens now to this jurisprudence that you must be able to obtain a share of all the property of the other spouse in certain circumstances? This seems now not to be possible under the phrasing that we are using. It would have been possible if we kept G.
Yes, exactly.
You see, which is wide. And I would vote that we give the court the widest possible discretion, and not just limit it to the first 7 years as we do in 2595.
There is a need.
The court has got to, because there will be certain cases where, for instance, let us assume there's a marriage that has lasted for a long time, 40 years, okay? And one of the parties has everything and the other one has nothing in their name, and that the property acquired during the marriage, which is a home perhaps, and I'll go back to the Paul McCartney story, is fine. You can share that, but over and above that, there are hundreds of millions in the bank, and lots of other businesses or income which only the husband has because he's a pop star or whatever has made. I don't think you can limit the share of the wife, if there is a breakdown, only to the matrimonial home that they've acquired together and ignore the rest of the wealth of the husband. I don't think that's fair. And I think because the wife has been used to a particular status and particular standard, etc., and has been there with Paul McCartney when he was still playing in nightclubs and earning £5 a night. Why should the fact that all of this money is made in his name not be shared with the spouse? And I think you need to give the court the discretion to give the other spouse, doesn't have to be half, but it can be 10%, it can be 20%, it can be a reasonable sum to compensate her for, or Madonna's husband in the other case, for the fact that the marriage has lasted a long time.
Thank you, Professor.
A quick point, is that not sufficiently covered by 2593?
Exactly.
There is a very wide discretion.
Yeah.
Thank you.
Okay. Just 1 second. Honorable Andre.
Thank you very much, Mr. Chair. Mr. Chair, my concern is with regards to 249, with regards to B, 249B. It states that the court the court may order one of the parties in the petition to make to any person for the benefit of the relevant child. But it doesn't state, because the way it is now, the relevant child needs, the person taking care of the relevant child needs to have been awarded either custody of the relevant child by the family tribunal. In this case, the way I look at it, it's like a mother and a father are petitioning divorce, and let's say the auntie takes the child for no good reason, takes the child to live with her. The court may order, under 246, may order one of the parties to pay maintenance to the auntie because it is in respect to the relevant child. So isn't this again, to me, causing uncertainty, because anybody can come and take the child, and the court may make an order to say for sustenance or maintenance of the child, I would order that you pay the auntie, you pay the cousin or whatever. So it needs to me, it needs to tie in with certain other words that had given the proper custody of the child for the time being to be maintained. Otherwise it becomes a bit of a chaos. Thank you.
Right. Honorable William, you had a point?
Should restrict it to people with
Thank you,
legal
Mr. Chair.
custody.
Mr. Chair, just wanted some further clarity. I mean, with regards to what Honorable Wawa was saying in terms of Article 50 and Article 249. I mean, I'm a little bit confused when you're talking about benefits, welfare, and maintenance, because I feel that I don't know if we have definitions. I mean, when the three should be used, because it's a little bit confusing how it is. I mean, it has been inserted within the text. Just wanted to point this out.
Okay. Thank you. Honorable Awi.
I have just a quick question, Mr. Chair. Maybe Honorable George can give us an answer to that. Now, based on what we're talking about in case of divorce, property being shared, and maintenance of child. Now, some countries, they now have the concept of prenuptial agreement. Can this be something that we can have here? And if so, how will that affect what we're discussing this morning?
Yes, sir. You can have it here. I'm told it is very rare, and it is expressly recognized in, I think, Article 1400. So the starting point, as has been mentioned previously, is that each party owns their own. Then there is the possibility, I think discussed yesterday, that parties may make a contract about who will contribute to the maintenance of the house. Will they have a community of property? Will it be a community of all property or a community only of acquisitions? That's a contractual matter. Then we come to these provisions, which are the default. So no provision is made. The parties each own their own, and then the Matrimonial Causes Act, for instance, says, well, there can be a serious injustice at the end of marriage because culturally all property may be in the name of only one of the parties, and after a marriage of 20 years or so, it's perhaps unreasonable to say that the person who has looked after the house, contributed the mortgage payments, should have no interest in the house, but at best be able to get their mortgage contribution back. So that's, the short answer to your question is yes, it's there, but I'm told not often used.
Okay. Honorable Runkalawan.
Yes, in line with that, in Mauritius, our friends can help us, but I have attended civil ceremonies. Before the partners actually go through the ceremony, the civil status officer actually asks them a question.
Yes.
Whether it's going to be, I mean, what they intend to do with their property, how it's going to be shared out. But here, this question is not asked.
No.
The fact that this is an issue, and a lot of people don't actually know, should we not include that somewhere? I don't know where, but should we not include that somewhere so that a couple getting married would have already decided that what is mine remains mine, or whether we will be having a common
Declaration of assets.
Declaration of assets. There will be another form of declaration of assets, so that it is clear, and hope not. Should there be a divorce, then everything is clear, and that would facilitate the
distribution.
The whole process, the distribution. Where can we insert that?
Thank you, Honorable. Professor?
My understanding of the Mauritius situation is that it is much closer to the French. In that situation, there are a range of, like a menu of matrimonial property possibilities, and in the French, at least, at the time of the creation of the civil status record, the act of marriage, there is a declaration as to the nature of the property relationship. If it is community, which means the parties become owners from then, this is actually highly relevant for creditors, for bankers, for people who supply goods. Do you need the signature of both parties? Who, in the case that the debt is not paid, who may I sue? So there is an important commercial consequence of parties saying, yes, we are in partnership now in respect of property. So that is the reason it's declared. And because Seychelles has not adopted the French pattern, in fact, you've opted into the British pattern in respect of matrimonial property, this question hasn't arisen, and the marriage settlement in the English system is very rare, except for the extremely wealthy. The other thing, I guess, is here the default rule is each person owns their own property, separation of property, a regime of separation. And therefore, the consequence of marriage for creditors is nothing changes, because if the wife makes the contract, the wife is responsible. And if she doesn't have property, well, that's a concern for the creditor. But it does not directly implicate the husband. So it could be useful that to have even here say, well, have you made a contract about your property? If not, the record could indicate séparation des biens. And that may well be best in the Civil Status Act. I think in the French it appears actually around the equivalent of Article 1400, saying, and at the time of the contracting of the marriage, the parties will indicate the regime that governs them.
So we're introducing community to a certain extent, but there is no presumption as such.
Well, you see, the default now is separation, but you can opt for community. You can, when you get married. In fact, we've seen occasionally, those of us lawyers who deal with marriage certificates, occasionally you see the civil status officer has added, and the part has crossed out separation of property and said the parties have opted for the regime of community of property. It's an option which you've got to exercise, otherwise you've got a default, which is separation of property, which is, in my view, a good default. Instead of going back to community of property, which is
complicated,
as the professor said, it has its own problems. But parties can opt for that, and parties can opt for a marriage settlement. And I think if we make a note for the future that if we are keeping the Civil Status Act for rules of procedure, we should insert something there so that we don't lose this idea that parties can opt. Marriage contracts are very rare for a very good reason. Unless it's somebody who has acquired wealth, and we see that. A very rich foreigner comes and marries a Seychelloise of modest means. That person will usually, especially if there are children,
of the previous marriage,
which we see, they will have a contract. And in those cases, we see them entering into a contract. Two Seychellois entering marriage will never enter into a contract. It's anathema. You're marrying out of love. You're not marrying for that. But occasionally we see, occasionally I've seen people come to me and say, I can't really ask her to sign a contract, but I want to make sure that my possessions as of today are listed. So what they will do, they'll come before a notary and make a declaration before a notary that I own the following property as at this date, and sign it, so that later on, if there's a problem, at least there will be a document evidencing this.
Maybe you can just clear Honorable Williams' query with regards to, I think you mentioned that in some articles we're using all three: payments, benefits, maintenance, welfare, maintenance, four.
Yes, we can adjust that.
Yeah. Okay, you want to say something about that?
No, okay. We'll adjust it. We'll standardize the word.
Yeah.
Honorable Sebastian Pilet.
Good morning, Mr. Chair. Good morning, honourable members. I just want to make 2 quick points. The first point is about the definition for relevant child. Is this not covered under the Article 228?
Which one?
228.
Yeah, it's a.
Yeah.
So
Thank you.
believe that there is a need for us to introduce provision for a definition. My second point is about our whole concept of interpreting the whole issue of marriage. I get the feeling we are now treating marriage as a contract of property, rather than what the Article 201 explicitly defines, that is, the spouses owe to each other faithfulness, support, sustenance, and care, whereby now we are looking at the whole concept of property. So I just want to get the gist of things, perhaps from more learned colleagues in the room, Honorable George, perhaps Honorable Wao. The amendments which we are making would also impact on people who are already in marriage, already having a relationship, a marriage, subsisting currently. And we, by introducing those clauses that recognize marriage relationships, are we taking away from what marriages really represent? Because I've looked at the prescribed time frames which we are talking about from marriage relationships in here, in terms of property distribution and whatnot. Specifically, if you look at Article 259, and we're talking about qualifying relationships. And in there, we say that the preceded by a domestic relationship. Now, what happens in the case of a person who was already married and was having a second relationship? Does the time which that person had outside, even though he was married at the time, will the time he has had with that bit on the side also be counted as the qualifying time for that marriage relationship? Will that be counted as well? So basically, he's got two hopes. Yeah.
Many irons in the fire. The matter has not been addressed, and so that is a significant issue. The converse is addressed, where an emménage relationship is followed by marriage between the same parties. Then the emménage counts towards the prescribed, the 7-year period. from memory, this does not address the situation of concurrent. And the intention, I believe, was that perhaps implied from en ménage to marriage, that would not count. That you could not benefit twice under that provision, but certainly it is not addressed.
Thank you, Professor. Honorable Afif.
Mine is more of a clarification. Are we changing the regime in the way property is partitioned after the breakdown of a marriage under this? Because I understood, you gave the example of McCartney. I understood that in the case of Seychelles, there is a clear manner in which this is defined. It's not left up to a judge to decide. It's droit de séparation de biens. That's what I understand that exists here in Seychelles. So are we changing this from what exists here in Seychelles, which is similar to what I believe exists in Mauritius?
Okay, Honorable.
Thank you. Thank you, Mr. Chair. No, Honourable. I think there are two things that we must not confuse. One is the regime under which you marry, which is either separation of property or a communauté de biens, community of property. It used to be community used to be the default here. It was then changed to become separation. Everybody who gets married here marries by default under the separation of property. What is yours, what is mine is mine. So that is the regime. But within that regime, the judge is given a very wide discretion upon the breakdown of the marriage, because we're still dealing only with marriages here, upon the breakdown of the marriage, to make adjustments to the separation, which is to move property from the one who is not the paper owner to the one who is the paper owner to the one who is not the paper owner, and to make them become co-owners, despite the fact that they married in separation of property. That is not changing. There's no change at all to that. The rules remain the same, subject to certain amendments which we will find when we come to 258 later. But essentially, the discretion lies with the court after the breakdown of a marriage, despite the fact that the parties are married in separation of property, to adjust the property belonging to them and to move that property around and achieve a global settlement.
Just one more question. Where we talk of a time period, for example, 259(1), you talk of the qualifying relationship which has subsisted for at least 7 years. And we're talking of en ménage. Who decides when it started? How do we define that? And elsewhere in, for example, 2596C, it also talks of the calculation of time. So how will that be defined?
When we're going to look at 258 and 259 in a minute, and up to now we're still talking about marriage and divorce. In a minute we're going to make a crossover to en ménage relationships as well, which we haven't yet. And this point will become very relevant because it is a point that we've been asked over and over and over again. You know when a marriage starts, because you have a marriage certificate, you don't know when en ménage starts. Perhaps we could leave that aside for the time being and go back to the marriage. There are essentially three large categories of evidence that the court looks for when making property adjustment orders after the breakdown of a marriage. And that is, number one, direct contribution by parties to the acquisition of the matrimonial property. Number two, indirect contribution. And number three, the duration of the marriage where there has been neither direct nor indirect contribution. So those are the three categories. And the court can, usually by a combination of those three, but sometimes even by the third one alone, the court can say, because this marriage has lasted for 20 years, and the wife has been a faithful wife, looking after the children and the house, etc., she has made no contribution at all, directly or indirectly. We will still give her 50% of the property, which is owned by the husband alone. So that can be done, and that is the current position. What we're now doing under 259 is framing this third category and giving it a time limit, which we will come to in a minute, and we're extending it also to aménage relationships. Essentially, that is the idea in 258 and 259, which will necessitate, which we will debate in a minute.
I think the fact that we've more or less shifted on it. Let's do it. 2 articles, 258, 259.
Shall we take on it now and start afresh at
Will there be
10:55?
Many queries on this?
Oh yes.
Yeah?
That will be a big one.
Okay. You've got a point on this, Honorable William? Okay. Let's see Honorable William, and then we take a break.
Yeah, Mr. Chairman, I just wanted to take a point, where Honorable George mentioned earlier on with regards to declaration of assets. Say, for example, before I got married, I had in my possession ABC, and then after being married, I got DEF. So, where we are at right now, do you think that it will be encouraging, or the tendency to have declaration of assets signed? No, because a lot of issues are coming up, because some people are a little bit confused. So what is advisable, in terms of the way forward? When you are talking, for example, if A, B, and C, I got that in relation with my brothers, sisters, and parents. And then after getting married, so how do we treat these cases? Official form.
Yes, Honorable George.
The simple answer is to do what I do, which is have no property and have no children. Then have no but I think this is what we try to address, Honorable, in 2591, which is it's only property which is acquired by the two which will be considered, i.e. in your scenario, DEF, and ABC, which you have obtained before, will not be considered. I think that's the point of departure, and it has to be like that. It has to be the point of departure. But to that, there must be some exceptions, and I venture to suggest that an exception will be where there is a huge disparity in wealth between the parties after a long period of time. But that really is a matter for discussion.
But isn't it better? If you go towards what Honorable William is saying, it's best maybe to declare before you go into that so-called contract, into the marriage.
Cynics will say it's best not to get married at all. But there has to be the problem is, you see, laws, Mr. Chair, are designed for people who don't do the obvious. They are there to protect the people who don't do these things. So you have to have a set of rules to assist them. If everybody signed a prenuptial agreement and made a will, etc., I wouldn't have a problem.
Yes.
But we must cater for the people who don't.
Okay, thank you very much. Okay, on this note, I think we'll take a tea break, and we come back at 11. All right? Thank you.